Hello, this video will serve as a short review for Unit 1, which will cover court systems. So what will the exam look like? The exam is 25 multiple choice questions. The exam covers material from chapters 1 and 3, and you will be allowed 30 minutes to complete the exam. You'll take the exam via As You Learn. The exam will open on Sunday at noon and will close on Monday at noon. You'll be sent an email in advance, which will give you the password and all of the additional instructions that you need to take the exam. On the practice exam, you will see a series of instructions laid out, and those are typically the types of instructions you will see right before the exam. Respondus is required for this exam. It is a department policy, and so you will need to have a webcam and make sure that you do the practice quiz so that you know that Respondus works. I would recommend doing the practice quiz before every exam just to make sure that you have the latest version of all the softwares and everything works well together. You will not be able to review your exam after the exam because of academic integrity issues and concerns around things like CHEG, but you can schedule a one-on-one time for us to discuss your exam as a whole. And so I would recommend doing that. If you go to As You Learn on the right-hand column, there's my virtual office hour slide, and below that it says click here to schedule an appointment. I have a zero tolerance for academic integrity violations, so any evidence of cheating will result in the highest possible disciplinary action. It's just unfair to your peers that are working hard to do the exam on their own. If you have any issues during the exam, please contact me. My phone number is listed below, and I'll see what I can do to assist you. Now, if it requires technological support, please be aware that Information Technology Services is only available on Mondays. It was only available on Monday because they're closed on the weekends. You should by now have access to the what I call brain dump, which is basically a list of all the topics that are covered on the exam. I literally go through the exam and say, okay, this question covers this topic, this question covers this topic, this question addresses these issues, and that's how I develop this brain dump. So this is just one tool that you should use to develop your study packet or whatever you're using to study for the exam. I would not use this as the sole source because you're just going to get hung up on the definitions and not really understand how these things work together. Now, every semester, students will take this first exam and then they'll look back at it and say, oh, I didn't realize it was as much applied information as it is. And so I would recommend making sure that you understand the definitions of things because you can't really apply them if you don't know the definitions, but then take it in that step further and really getting into the application side. There are some great practice activities on McGraw-Hill if you have time to do those. Otherwise, there's some practice questions at the end of the chapters that might have some more applied examples in them as well to check your knowledge of the concepts. So I'm going to go over a couple of topics that I get asked a lot of questions about just as kind of a preview to our live review. The first question I get asked is around alternative dispute resolution. Students sometimes have a difficult time distinguishing between mediation and arbitration. Now, negotiation is kind of the easy part, right? That's where we are just negotiating, maybe it's a term of a contract or maybe it's a price point of something. There's not a lot of formality to it. So I'm going to break down mediation and arbitration. So when we look at the difference between mediation and arbitration, mediation, it's listed at low to no cost, but a lot of times there's a cost to have the mediator. And arbitration, because you're dealing with an arbitrator, usually comes at a little bit higher cost. And a lot of times parties still have their attorneys represent them at arbitration. So the cost is generally a little higher for arbitration versus mediation. There's usually less delay getting a mediation set up than there is an arbitration. If you remember, arbitration still kind of has a formality to it, and so you have to, submit your pleadings of sorts, your documents, kind of like your complaint and answer style documents, and then you have an actual kind of hearing where the arbitrator hears both sides of the case. Mediation tends to have a win-win outcome because we're talking about, ways that the parties can both walk away somewhat satisfied, if not completely satisfied. Whereas arbitration usually has a win-lose scenario where we have one party that walks away winning and the other party that walks away losing. As a result, mediation is more collaborative. We're trying to come up with a mutual solution, and arbitration is more adversarial, kind of like the traditional court system. The maximum range of kind of outcomes in mediation, it can usually be more than just money. Sometimes it's restoration of relationships. Sometimes it's policies, change to policy. Sometimes it's an apology, and sometimes it's a change to policies. Whereas arbitration is more or less going to result in some sort of monetary award or injunctive relief. Mediation thus allows us to improve and maintain relationships, again, circling back to that win-win outcome, collaborative in nature, oftentimes results in solutions that are more than just money. And arbitration, like trial, may damage a relationship. In mediation, remember we have both parties and a mediator, but the parties are really the folks empowered to make the final decision. In arbitration, we still have parties, and we have someone in the center that we call the arbitrator, but the arbitrator or panel of arbitrators are the decision makers. And when you're trying to visualize the difference between these two, arbitration is kind of what you see on court TV, where you have someone kind of up front of a room and you've got your two parties on each side. Whereas I can see mediation where folks are sitting around the table and maybe the mediator's at one end of the table and the parties are sitting across from each other. The next question I get asked a lot is really a confusion around jurisdiction. I really want you to think about jurisdiction as part of a puzzle that we're trying to put together to get our case to trial. Jurisdiction answers the question, am I in the right place? And there should be a question mark there. And am I in the right place given the parties that are a part of this dispute, given the topic, and given the location of where we're trying to bring this dispute to? Personal jurisdiction is jurisdiction over the defendant. Remember, I as the plaintiff am bringing this cause of action to a particular court. So I need to prove to the court that this court can hear this dispute over the defendant. And if you think about it, when you were a kid, who got to discipline you? It was probably your parents or whoever you lived with. Random people on the street didn't get to just discipline you. And so this is kind of like that. Personal jurisdiction answers that question. Who has the right to provide those consequences to the defendant? And these are the different ways we establish personal jurisdiction. Where you live, that's domicile. And the long-arm statute is one way. And long-arm statute, remember, is a statutory law in each state that says these are the different scenarios in which we allow a person to be an out-of-state defendant to be brought into our state. And remember, there's that constitutional piece of minimum contacts that has to occur in order for a long-arm statute to be applicable. So these are all different ways that we can prove that the court has authority over the defendant. Subject matter jurisdiction, on the other hand, deals with jurisdiction over the topic. Now, if you think about it, not every court should handle every topic. And so we've got this court of general jurisdiction that's kind of the bucket that everything goes into. And then we have courts of federal we have federal courts, we've got bankruptcy courts, we've got probate courts, all these different specialized courts. And so that's where we start talking about questions of federal question and diversity jurisdiction. Those are two questions that we ask, and in order to get into federal court. And remember, diversity of jurisdiction, your amount in controversy has to be over $75,000 and your parties have to be citizens of different states. And that's how we get people into federal court. Now, why somebody wants to go to federal court over state court? There might be concurrent jurisdiction. That's where we can get into jurisdiction to multiple places. There might be original jurisdiction or exclusive jurisdiction, like federal questions dealing with the U.S. Constitution. The federal court's going to have exclusive jurisdiction over that. And then venue is where the actual courthouse is located. Are we in the proper place in front of the right judge in the right building? And remember, these things are mostly brought up during the pleadings or the complaint and answer process, amended complaint, amended answer process. And an extremely large percentage of cases don't go past this stage of pleadings. They get dealt with on a lot of motion to dismiss, and there's so many of them that we're not going to get into those. And some of those motion to dismiss calls can be for jurisdiction issues. If I'm the defendant, I don't want to be dragged into court in Utah, and I've never been to Utah, and I've never done business in Utah. A good way for me to try and not have to incur the expense of finding a Utah licensed attorney to deal with this Utah dispute is to really try and fight it at the pleading stage. So this is, despite what you see on TV, this is where most cases really end. Discovery is another question I get asked about. So remember, discovery is the process that allows parties to learn about the facts so they aren't surprised in court. Surprise discoveries, where you have this last minute bombardment of people running into court, is really a thing for TV shows, and it makes for great TV, but it's not really realistic. A lot of the surprises are pretty much dealt with in the pre-trial hearing and pre-trial conference. So usually once we get past the pleading stage, and maybe somewhat simultaneously with the pleading stage, we'll start collecting interrogatories, requests for documents, and maybe some depositions. So if you can imagine a scenario where you own maybe you own a grocery store or a clothing store, and somebody slips and falls on your property, and they say it's because you were negligent, something that we're going to get into in the next unit, then you may want to interview the folks that were around that saw the person fall. You may want to interview the management to see what the protocols are. You may want to request production of documents, meaning the person who fell, you might want their medical records. You may want to do some searches to see if they've fallen before and filed claims like this before, if this is something that they do on a regular basis, or if this is a genuine claim. And you may want to depose the person who fell in anticipation of going to trial. And some folks will depose folks before trial because they're not sure if they're going to be around during trial. And so there's, I think, a couple of examples raised in your book around that. All right, so hopefully this is enough information to get you started in studying in preparation for our live review. So please check As You Learn for the date and time of the live review, and you should have a Google invitation, etc. Have a great day.